Before we begin the semester, it is useful to understand the course's overall perspective and approach to the material. This brief introduction will also make sure we are all on the same page as we begin the course, as some of you may come from different disciplines. As the title of this course suggests, we will examine the justice system within the American political process. The purpose is to provide a general overview of the American justice system, both criminal and civil, and to understand its operation within the larger political context. Courts can be discussed as both legal institutions and political institutions, or the justice system as a legal system and as a political system. What do you think we mean by the difference between legal and political? As a legal system, there are major structures and basic legal concepts, rules, and processes that underlie the American judiciary. As a political system, there are corresponding institutions within which individuals must make discretionary choices. The law is not self-executing, as there is an element of interpretation. The role of key participants, such as police, attorneys, judges, and jurors, within this legal and political context is therefore important, and we will examine each of these over the course of the semester. Furthermore, within this legal and political system, there are distinct civil and criminal justice processes. Overall, by the end of the course, you should therefore have a good understanding of both the civil and criminal justice processes and how they differ within this judicial system. The overall approach to the course material is a political science approach, rather than a legal approach. So what do we mean by political science? What do political scientists do? Political science is the systemic study of politics and government. So we are looking at the system, the interrelation of the different institutions and the actors within these institutions. I would add that in order to fully understand the system, you need to consider the institutional incentives and resources within which the individuals are working. So, for example, when we think of judges, we think of them as being independent from politics. They are supposed to be removed from the electoral process so they can focus on interpreting the constitutionality of the laws. However, in some states, judges are elected, so they have an incentive to get reelected, but their resources are such that they can't look too much like they are campaigning like a regular politician, because that would make them look beholden to their contributors and thus too political. There are many ways to define politics and government. So what is politics? What is government? Hopefully you took some time to write down some notes about your definition of politics. There are many different definitions out there for politics. What elements did you think are essential for a working definition of politics? Many of you probably said something about politics as a process, or politics has something to do with debating about values, or allocating funds in society. So one of the definitions I like to use is politics is the process by which society decides who gets what, when, and how. Or as some texts define it, politics is the authoritative allocation of values for a society. So think about whether or not your definition that you came up with would coincide with this definition. So what is government? What elements did you have in your definition? How do you know a government when you see it? What does a government do? Most of you probably included something like it being a system or an organization. Most definitions include some element of authority. Governments have some authority over the people that live there, which leads to another important element. Governments have to have authority over a particular area and the people that live there. It has to be bounded. So the definition I like, that includes all these elements, is that a government can be defined as a system or organization for exercising authority over a body of people, or government can be understood as the institutions, processes, and rules that are designed to facilitate control of a particular geographic area and its inhabitants. Regardless of the exact definition, clearly the courts are political institutions in that they are part of the process that decides who gets what, when, and how. And they are also part of the structure that facilitates control over the people living in this country. So throughout the semester, we will be exploring the judicial system and how it works within this context of politics and government. So how many of you have read the Federalist Papers? Does anybody remember what their purpose was? The Federalist Papers were written anonymously by James Madison, Alexander Hamilton, and John Jay after the Constitutional Convention in order to convince the states to ratify the proposed Constitution. So it's a great place to look if you want to understand why the framers designed the Constitution the way they did. Why is the Constitution structured the way that it is? Why is our government designed the way that it is? So for those of you taking the class that want to become lawyers, you will most likely read these papers in law school. In the Federalist Papers, the framers referred to the court as the least dangerous branch to the rights of the Constitution, and sometimes the courts have thus been referred to as the third branch of government. But I think as history and contemporary politics illustrate, the judiciary is an equal participant in the governing process. Courts engage in the political process equally with the other branches of government, even if they are distinctive in many ways. This is different than my making the argument that the court is more active or restrained. It is just making the argument that the court is an equal branch of government participating in the governing of our nation. The slide you see now displays many of the elements and institutions central to our governing process. Upon examination, it becomes clear how the courts interact with all aspects of our governing process. Look at the list. Can you think of any ways that these connections are illustrated in society? As an example, I would like to highlight one of these that is particularly important for understanding the judicial system and the American political process throughout the rest of the semester, and that is the courts and federalism. At first look, our court system demonstrates our federal constitutional design. We have a whole state court system and a complete federal court system. This design is a result of a debate that took place at the Constitutional Convention between Federalists and Anti-Federalists. The Anti-Federalists wanted the state courts to be superior, while the Federalists wanted the national court system to be superior. The compromise was to create the Supreme Court and leave the rest of the structure to be established by the legislatures over time. Where to draw the line between the respective powers of the state and national governments has been one of the longest-running political battles in the United States. It is probably one of the central debates between Democrats and Republicans today, and I believe central to many of the heated debates that take place in larger society as well. For example, the legalization of marijuana, immigration, gun control, and healthcare policy are all controversial issues today and all relevant to federalism. Even the development of HB 2 reflects an element of federalism. Although the media and popular dialogue may focus on the controversial nature of the subject matter, at the center of these debates is federalism and court decisions that set precedent concerning who and how these issues should be regulated, by the states or the national government. An example we'll talk about now is the legalization of marijuana issue. As of January 2018, 30 states and the District of Columbia currently have laws broadly legalizing marijuana in some form. 7 states and the District of Columbia have legalized marijuana for recreational use. What's interesting is to see what this map looked like in the fall of 2016, only a year and a half ago. Only 25 states had laws broadly legalizing marijuana in some form, and only 4 had for recreational use. But what is interesting for our purposes is the federalism aspect, that the states are acting independently despite what the Supreme Court and the federal law says. Over the past 4 decades, advocates of rescheduling marijuana have been thwarted by DEA delays. The U.S. Supreme Court has declined to hear appeals from medical marijuana advocacy groups on multiple occasions to legalize the medical use of marijuana under federal law. Federal law labels marijuana an illegal controlled substance. In one unanimous 8-0 ruling, the High Court ruled that patients with debilitating diseases who take the drug to relieve their pain would be doing so illegally. Justice Clarence Thomas wrote in the opinion, "Congress has made a determination that marijuana has no medical benefits worthy of an exception." So notice, it's Justice Clarence Thomas in the opinion is saying that Congress has made a determination that marijuana has no medical benefits worthy of an exception. So that's federal law, federal statute. So now when President Bush was in office, he directed his attorney generals in the states to prosecute to the full extent of the law, regardless of state laws regarding medicinal use of marijuana. When President Obama came into office, he directed the attorney generals differently in the states. He said, do not prosecute to the full extent of the federal law and judicial precedent by not interfering with the states that voted to legalize the drug, as long as the legalization did not interfere with other federal laws. So think of things like drug trafficking. Now, a few days ago, the Trump administration, that's now in office, has announced that the Justice Department would be reversing several Obama-era rules pertaining to states that legalize marijuana. You can see some of the links about this reversal on the Moodle page under relevant links and files. So specifically, the Trump administration has said that prosecutors should take into account a department's resources, the seriousness of the crime, and the deterrent effect of the prosecution before filing charges. So, for example, while a judge might not choose to prosecute a marijuana business for growing or selling, he or she could choose to do so. So that means getting involved in the industry, even in states where it's legal, is now a bit of a gamble. And then technically, people like growers and dispensary owners can now be prosecuted in recreational legal states. And what that move could mean would be that investors would be less likely to fund marijuana-based companies. The point here is that courts and federalism are central to this debate and relate to the other branches and institutions in the political system as well. Although we focus on the controversial nature of the topic, drugs, the legal issue centers around federalism. Should the states or the national government have power to regulate this issue? Congress, the courts, and the executive are all involved in this question. When we speak of the courts as legal institutions, we are referring to the legal structure of the court system. One way to conceptualize this is in terms of three rings, like a bullseye, with an inner ring, a middle ring, and an outer ring, all within the context of larger society that includes social, economic, and political forces. The inner ring consists of the institutions of law and the courts. Law is the body of rules enacted by public officials and backed by the force of the state. Courts decide disputes based on the law. What is key here again is that all three branches of government are active participants in deciding what the law is and how fast it changes. Notice if you look at the three branches of government, we often conceive of Congress as the primary lawmaker, the executive as the institution that implements the law, and the judiciary as responsible for settling disputes on the basis of the law. But this view is somewhat oversimplified because the courts in the United States don't just interpret the law enacted by the other two branches of government, they also input into the political lawmaking process. They are part of the political process of fitting the law to the needs of a dynamic society. And this is true whether or not you believe the court should be active or restrained. Even a restrained court makes decisions that impact how the U.S. is governed, and the policy-making decisions and actions of the other branches of government are impacted by judicial decision-making. For example, oftentimes the policymakers in Congress and the executive branch will wait for a court decision that they know is coming before they make policy decisions relevant to that court's decision. So the middle ring consists of interpreters of the law. These are the lawyers and the judges, and I would also argue the police and the juries. These are the institutions and individuals that are the gatekeepers. The outer ring consists of the consumers of the law. These are the individual citizens like ourselves, interest groups, defendants, plaintiffs, victims, etc. These are the ones who are impacted by the inner and middle ring. These are the ones who are asking for a resolution by the courts, calling a lawyer, or being sued. These three rings all operate within the larger society, which includes social, economic, and political forces. For example, September 11, 2001 changed societal views about terrorism, which potentially impacted the debate concerning military tribunals. Social attitudes towards marriage, for example, have changed, thereby increasing the number of divorce cases or the debate over gay marriage. Or most recently, the events in Connecticut and Sandy Hook and other mass shootings that have occurred since then have led to a flurry of discussion regarding gun control. And then concerns over the high price of medical and automobile insurance have prompted calls for tort reform. Or during the New Deal era, when FDR became frustrated with the Supreme Court's decisions that hindered his New Deal legislation, he actually went to Congress and proposed the court packing plan that would have increased the number of justices. It would have been unconstitutional, but it would have allowed potentially his program to go forward. Instead, For an unknown reason, the court reversed precedent in terms of allowing government regulation of the economy, and this is what they called the stitch in time that saved nine. Lastly, as we discussed earlier, although courts are clearly political institutions and similar in that they are part of the political process in society, determining who gets what, when, and how, and settling disputes, it is important to note that the courts are also different than other political institutions. And I'm sure if somebody asked you how are they different, you'd come up with things like courts are generally passive and reactive. They have to wait for controversies to be brought to them. And unlike individuals in the other branches that have more discretion in choosing which issues to address, judges must make decisions on the cases before them. And lastly, the judiciary is more insulated from political activities such as elections and lobbying.